Hello everybody. You all have heard about different kind of bodies, constitutional bodies, statutory bodies, regulatory bodies, quasi-judicial bodies. Now why there are so many bodies? Are all the same or there are differences? So I am going to make an interesting discussion on this topic. Today I am leading with constitutional bodies. Now we have number of constitutional bodies in India. Now constitutional bodies are not definitely statutory bodies, regulatory bodies or quasi-judicial bodies. They can have some regulatory works, they can have some statutory works, they can have some quasi-judicial role, but they are not definitely identical to them. Constitutional bodies have their own constitutional status. Like we have a number of major constitutional bodies I am referring to is Finance Commission, is then Goods and Services Tax Council, then UPSC and state PCS bodies, the Election Commission of India, then Comptroller and Auditor General Office, then Attorney General, then Advocate General, then Interstate Council, then National Commission for Scheduled Caste, National Commission for Scheduled Tribes, and some others. Now see that each one of them, like Finance Commission is linked to Article 280 of the Constitution, UPSC State PCS is linked to 315 to 323, then Election Commission of India is linked to 324, CAG is linked to Article 148, and Attorney General, Advocate General is linked to Articles 75 and 165 respectively. And then Interstate Council is linked to Article 263, and National Commission for Scheduled Caste is linked to 338, and NCST, National Council for Scheduled Tribe, is linked to 338. So that means each constitutional body is essentially linked with one or more constitutional provisions or articles. Now even in that respect, Parliament is a constitutional body, Executive is a constitutional body, Judiciary, all are constitutional bodies. In a number of judgments, the Supreme Court has established this fact that even the local government, since they are formed under 73rd and 74th Constitutional Amendment Acts, therefore they are also the constitutional bodies, and from the 11th schedule, a number of items, number of subjects have been transferred to the local governments. Parliament has also ensured that the panchayat does not play the role of merely executing some programs, but they will also formulate their own programs based on their own power and authority. So this is what is the provision now. And see that by virtue of the provisions contained in Part 11, the panchayats have been empowered to formulate and implement their own programs. They are not merely executing the programs of the state governments or the central government, but they can have their own programs of economic development and social justice. In tune with the status as the third tier of government, which is mandated to represent the interest of the people living within its jurisdiction. Now then, why some organizations and institutions are called constitutional bodies? First, the appointment and removal of the chief functionary of the constitutional body is essentially based on the recommendation of the cabinet of the central government and will be appointed by the President of India. So it is based on cabinet proposal and through the office of the President. Then their tenure, their salary and their functions are again governed by the constitutional provisions. So it will be more or less in the broad outline that has been laid down in the constitutional provisions. So that is how their functions will be governed. Now, what is the significance of the constitutional bodies? What is the significance of the constitutional bodies? First, they derive power and authority from the Constitution. Since they derive it from the Constitution, therefore Parliament does not have any scope to interfere into their functioning unless there is an amendment accordingly to intervene into that area. Otherwise, Parliament cannot do. Secondly, any change in their power or authority requires a constitutional amendment. Until that is there, then no government can interfere into their autonomous functioning. They function more independently and are permanent in nature. So definitely, therefore, they enjoy a lot of autonomy and independence, and since constitutional amendment cannot be so easy, therefore they remain as a permanent body under the Constitution. They are the bulwark of the democratic system of India. So these bodies actually they keep our democratic system stronger and in right place. So that is their role. Now, in view of it, let us see one or two questions. First, now there is a question in 2016, very interesting question, that exercise of CAG's power in relation to the accounts of the Union and the state is derived from Article 149 of the Indian Constitution. Discuss whether audit of the government's policy implementation could amount to overstepping its own jurisdiction. Okay, so if CAG enters into the auditing of the government's account, then whether it makes an overstepping of its jurisdiction. Now, what do we require in this particular question? We must know that the power and function of the CAG is described in Chapter 5, Article 148 to Article 151. Section 149 is very important because that describes what its power is. It says the CAG shall perform such duties and exercise such power. Okay, so those power and those duties it will perform in relation to the account of the Union. So that means it has an access to the account of the Union and of the state. So it has no access to that. Constitution has given its power, and any other authority or body as may be prescribed by or under any law made by Parliament. So as may be, or any other authority. Okay, even other authority it can go, whichever the parliamentary any law passed by the Parliament permits its rule. Now, when it is constituted, it is constituted by the President every fifth year means that is Finance Commission. Okay, every fifth year, CAG is constituted every fifth year or such other time as it is deemed necessary. It is known as the fourth pillar of the Constitution. So these are very important terminologies. So it is the fourth pillar. It is known as the fourth pillar of the Constitution, and the CAG ensures that the appropriations made by the Parliament have not been exceeded without proper sanction. That means, whatever is there in the budget, government cannot, suddenly include some other programs and start spending on this. This is where the significance of the budget, and CAG will look into that. Or it cannot exceed suddenly. So all these things will be under this scanner of CAG. It audits the accounts related to all the expenditure incurred by the central and state governments and ensure that they spend money in the manner authorized by the legislature. So that means a state and central government can spend money only in the authorized area which has come from the respective legislative body. So CAG will see whether the expenditure has been done according to that or not. Then it audits the accounts of bodies and authorities financed from the central or state revenues like corporations, companies, etc. So if somebody uses government money, it can also go into that area and audit their financial status. It submits its report to the president. Now all the constitutional bodies are recommendatory bodies. They are not the final authority to take the decisions. Their role is to do their work and then submit the report to the president. Now president will then make the comments, necessary comments, and then through president it will be placed before the parliament, before the houses of the parliament, with an explanatory notes from the president's side. This is not the area on which CAG will be doing. CAG's role ends the moment it submits the report to the president. So this is where CAG's role comes. So there you will be understanding that how constitutional body functions. Let us take the another example. This is a 2018 question. Whether National Commission for Scheduled Castes can enforce the implementation of constitutional reservation for the scheduled caste in the religious minority institutions. Explain. Okay, now for this answer you'll have to know certain things, that National Commission for Scheduled Caste is a constitutional body and constitutional safeguard is there for this body. This commission functions, or it draws its power authority from Article 338. Now it has been renamed. It was along with the constitution, then it was renamed in 1987 as the Commission of SC and ST. Then again it has been changed under 65th Constitutional Amendment Act in 1990, and it became the Commission of SC and ST. So this was renamed, and this was finally through the Constitutional Amendment Act, this becomes a constitutional body. Okay, so this name does not become constitutional name because it is not through the constitution. Now in 1990 it becomes a constitutional name. So therefore it is now a constitutional body. Again it has been changed in 2003. Now this has been bifurcated, as one is Commission for SC and another is Commission for ST. Okay, so therefore it is also 89th CAA creates a new article, inserts a new article called 388A. These are the basic facts you must include in your answer. Then Article 388, what does it say? It says there shall be a commission for scheduled caste. That means this establishes the commission for SC. And Article 15, what does it say? Article 15 is prohibition of discrimination on the ground of religion, race, caste, sex or place of birth. So Article 15 gives the safeguard that nobody can be discriminated based on these areas. Okay, and Article 15.5, what does it say? It says that to make reservation with regard to admission into educational institutions, both privately run and that are aided by government. Now, Article 15.5 says that yes, there can be reservation, okay, regarding the admission in the educational institutions, both private and public schools or institutions. But there is a caveat. What does it say? That minority institutions are exempted. Okay, so therefore these reservation cannot be implemented in the minority institutions. Now see the question, what does it say? That whether National Commission for Scheduled Caste can enforce implementation of constitutional reservation for the scheduled caste in the religious minority institutions. So now we have seen that this cannot be done because minority institutions are exempted. Minority institutions have been exempted. Okay, so 15(5), while it gives power, but it keeps minority institutions separate. Therefore, these cannot be done. Fine. Now, Article 30, that is also very important article here in this question, that is right of minorities to establish and administer educational institution. So, Article 30 gives the provision for establishing minority institutions in the country. So, therefore, this is a constitutional right, and Article 30 comes under Part 3, fundamental rights. Therefore, this is the part of the basic structure too. There are some important cases also can be mentioned in this particular answer, like St. Stephen versus Delhi University case 1992. Here minority institutions, not 505, it should be 50. It should be 50%, okay, up to 50% reservation can be implemented in a minority institutions. That is what is St. Stephen case. There is another case, very interesting case, Asha Kumari versus State of Bihar and Anita Kumari versus State of Bihar, 2006. The number of cases have been clubbed in that particular case, and where it says that, the main demand was that whether physically challenged women can get the reservation in a minority institutions. The Supreme Court decided that if physically challenged women get the reservation, then these reservation provision has to extend to other groups also, because there cannot be discrimination on the ground of anything. If that is the case, then these women will not get reservation in the minority institutions. Therefore, even for the handicapped or physically challenged women or a special section, special group, reservation cannot be extended to the minority institutions. Next is Sindhi Educational Society case 2010 versus the government of NCT of Delhi. In that case, Supreme Court said, because the main demand was there, whether in the recruitment of the teachers there can be a reservation for SCs and OBC quotas. In that case, Supreme Court again says, if reservation is prohibited in the minority institutions, it should be implemented in all respects, not only on the admission of the students, but also admission of the teachers in those schools. Fine. So these are the cases, and all these commissions will finally submit their report to the President of India. So that is the thing. They are recommendatory body. They are not the final authority. Final authority remains Parliament. So thank you very much.